action by which a party sues another for enforcement or protection of a right or prevention or redress of a wrong. So what are the keywords here? Enforcement, protection of right, prevention, or redress of wrong. Tandaan nyo, enforce, protect, right, prevent, redress, wrong. Okay. Remedy by which a party seeks to establish three things. Status, right, particular fact. Okay. Ano yung sa television, yung commercial? SRP. Ano yung SRP? Suggested retail price. So, tandaan nyo, to establish S
let us try to analyze ano ang ibig sabihin ng progressive scheme of taxation sa Constitution. Ano ang ibig sabihin nito? Okay, ang ibig lang sabihin nito is whenever the Congress is enacting a tax law, all right, they should try their best to address their intention to the ability to pay principle of the people. Okay? So they should come up with many rates from the lowest to the highest. So that is what we call progressive scheme of taxation. So you will see na ang ating income tax tumutugma sa progressive scheme of taxation because sa tax code, ang income tax rate ng individual taxpayer
This is before the amendment. And for every allegation, it should be supported by evidence. Because evidence is the means sanctioned by the rules in a judicial proceeding to establish what? That equals to the truth. So if there is an allegation supported by evidence, then you're able to establish to the truth. But now it has been adjusted. Kindly take note of that. Why? Because today, for purposes of filing a pleading, for purposes of initiating a complaint, and this would include all other pleadings, even responsive pleadings, what is now the requirement of Rule under Rule 6? That together with the pleading initiatory pleading, which is made as an integral part thereof, would be what? Judicial affidavits.
What is our definition of the practice of law? We have three very good definitions of the practice of law. The practice of law is a profession. It is not a business or trade. Lawyering is not primarily meant to be a money-making venture. And law advocacy is not a capital that necessarily yields profits. Duty to the public service and to the administration of justice should be the primary consideration of lawyers. And gaining a livelihood is a secondary consideration. Very good definition, easier said than done. So our primary consideration is to administer justice. Gaining a livelihood is a secondary consideration only for us lawyers. Another definition of the practice of law is
First, let us speak of the principles of generality and territoriality. Remember that questions about these two principles were asked in the 2015, 2017, 2018, and 2019 bar examinations. Okay? So far as generality is concerned, consider the persons which are exempt from the general application of Philippine criminal law by virtue of the principles of public international law, and the person exempt from criminal from the application of Philippine criminal law are the sovereigns, chief of states. We have ambassadors, ministers plenipotentiary.
The employer embark on a retrenchment program only if it was experiencing actual losses. Not necessarily. In the words of the Supreme Court, if the employer can perceive that sooner or later the economy of the company will go down to the drain, then it should do something. The employer of the company should do something. It should not wait anymore for that time or period that the employer or company incurs actual losses.
In Spouses Minjola v. Court of Appeals, the Supreme Court devised or laid down tests in determining whether a counterclaim is compulsory or permissive. There are 4 questions to be asked, my friends. The first question is, you check. Okay? Sabi ko, compulsory or claim arises out or it is necessarily connected with transaction occurrence which is the subject matter of the complaint. Pag sinabi mong compulsory counterclaim, kaibigan, it is an offshoot of the complaint. There is a logical connection between the counterclaim and the subject matter of the complaint. Kaya sa bar exam, tinan nyo ang 4 na test na ito. Number 1, are the issues of fact or law raised?
What is a dispute? The dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between 2 persons, natural or juridical. In the Republic Act 9285 or the ADR Act of 2004, it is defined as a process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof. So we take note of the meaning. It is a process or a procedure.
We have also these provisions in the Constitution indirectly affecting taxation. One is due process, and there are 2 aspects of due process: procedural due process, and of course, the substantive due process. You know what is procedural due process? Well, if the imposition of a tax requires certain steps or legal processes to be followed, well, failure to follow them would make the act a violation of due process. One good example here is the assessment of taxes by the Bureau of Internal Revenue or by the government, where the procedure is laid down under Section 228 of the National Internal Revenue Code. So, any deviation from those rules would be a violation of procedural due process.
Now take note under Rule 58. There are 2 kinds of injunction: preliminary mandatory injunction, preliminary prohibitory injunction. Now, lifetime of a TRO issued by the RTC, by the Court of Appeals, and by the Supreme Court So if it is issued by the RTC, you have 20 days. Within the 20-day period, then there shall be a hearing. The hearing is mandatory as regards to the application for preliminary injunction, either mandatory or prohibitory. Now, after the lapse of the 20-day period and there is no injunction issued, it becomes pactus officio. Now, as far as Court of Appeals is concerned, the lifetime is 60 days. Now,
it is provided in the Constitution that the JBC, the Judicial and Bar Council, shall be composed of 7 members. The Chief Justice as ex officio chairperson, the Secretary of Justice, very specific, as a member, ex officio member, and then a member from Congress, and then 4 other regular members, a representative from the retired Supreme Court justices, very specific, a representative from the integrated bar, a representative from the private sector, and then a representative from the academe, professor of law. This case of Chavez versus JBC, it's included in this slide. I'm sharing simply because there was an issue actually on what a member.
When party rests his case and real evidence consists of objects offered in court. Example, you may use a physical object to demonstrate its existence or identity. Like for example, the serial number on a computer found in a private residence could identify it as a government-owned property. Or for example, the gun that was used in case of murder. Now, the other type will be testimonial evidence. And what is testimonial evidence? You call a person to take the witness stand and his testimony is being offered to prove specific purposes. The third type will be your documentary evidence. It is formally offered by the proponent immediately before he rests his case. A document may be an object evidence or a documentary evidence depending on the purpose.
What is involved is what appears to be a discriminatory act on the part of government or agents of the government. The proper right to invoke there is the right to the Equal Protection Clause. Because remember, the right to the Equal Protection Clause is a right against any kind of discrimination or discriminatory act on the part of government. So that is a broad formula. So if what is involved, I repeat, is an act of government that appears to be arbitrary, whimsical, capricious, oppressive, unreasonable, confiscatory, and you want to challenge that, you invoke your right to due process law. On the other hand, the Equal Protection Clause is a guarantee against any kind of discrimination or discriminatory act.
Day to our dear attendees from different parts of the country. I pray that you're all in great state of health. This free webinar is streaming live via the Villasis Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section #VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of Villasis Law Center. Allow me to share to you this good news. The Virtual Law Companion is the newest innovation of Villasis Law Center, which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 through any web browser, using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.villasislawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual claps and welcome our lecturer today. Again, this free webinar is brought to you by our Virtual Law Companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Our lecturer is the Dean of the Graduate School of Law at San Sebastian College Recoletos in Manila, or SSCR. His initiatives for the Master of Laws program has helped animate the Graduate School of Law education in the Philippines. He has been a consultant of different institutions such as National Consultant for ADR of the United Nations Food and Agriculture Organization, Consultant for Intellectual Property at the Cultural Center of the Philippines, Consultant for the Project Alubasa of the Department of Trade and Industry Philippines, Consultant for the Bureau of Fisheries and Aquatic Resources on the Adjudication Rules, and City Government of Parañaque. Other than the mentioned consultancy work, he is a consultant of various corporations and individuals as part of his being a founding owner of Tadan Law Office. He is a writer and columnist at Pragmatic Principles or Presson.ph. He is likewise an advocate of consumers' rights as president of the Consumers Union of the Philippines, Education of the Youth as president of the Boracay Island Global Academy. As professor, he is connected with University of Santo Tomas, Polytechnic University of the Philippines, SSCR Law and Graduate School of Law. He is also a mandatory continuing legal education lecturer for various subjects. Without further ado, please welcome Dean Rodel Taton, DCL.
Good day, everyone. I am Dean Rodel Taton, and welcome to this free online lecture brought to you by the Virtual Law Companion of Villasis Law Center. Prepare for the bar examinations at any time, anywhere, and from any mobile device. Check out the VLC website at www.villasislawcenter.com for more details and particulars. Optimize this learning opportunity. Like the VLC Facebook page and share this FB Live session. Host a watch party via FB and tag your friends now, and together learn at the comfort of your homes. Before we start, please comment VLC if you can hear me clearly. All right. So you can hear me clearly. So let me begin my lecture for today, a 1-hour lecture actually for all of you who are preparing for the bar examinations. and my topic is alternative dispute resolution, which is a component of the bar examinations 2020, and it is included in the bar review bulletin. So for today, we will be discussing alternative dispute resolution, and we will try as much as possible to discuss the many aspects of ADR in our 1 hour session. Although we know that the 1 hour is not enough for the discussion of all the aspects of ADR, but we will try as much as we can here today. Okay? So we'll try to cover the general concept of dispute settlement, mediation and other modes of dispute settlement, arbitration, the rules governing arbitration or the legal aspects of arbitration, which would include RA 876, the ADR Act of 2004, the implementing rules and regulations, the special rules of court and ADR, the New York Convention, the international arbitration, international commercial arbitration, and of course, our special rules of court. And we'll try to cover also the many cases decided by the court, but just in an hour. But we'll try our very best. But if we cannot cover everything this day, I know that you'll be enrolling in VLC, and you will be able to discern all the aspects of ADR in your preparation for the bar examinations. So what is a dispute? As a starting point, we wanted to understand what is a dispute. It is a disagreement on a point of law or fact, a conflict of legal views or interests between two persons, natural or juridical. So take note that there is a disagreement in point of law or fact, and there is a conflicting legal view or interest between two or more persons. So it can be between two persons, juridical or natural, between a corporation and an individual, or it can even include state and a juridical person. Alternative dispute resolution in the ADR Act of 2004, which is the RA 9285, is defined as a means or a process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof. So here we distinguish basically ADR as against the adjudication of a presiding judge of a court, or we often refer to as litigation. In our later slides, we will be discussing that as well. Okay, the Supreme Court has been promoting the use of alternative dispute resolution mechanisms, or ADRs, like arbitration, mediation, negotiation, and conciliation. And this would enable the parties to amicably settle their disputes. That would be less time consuming, less tedious, less confrontational, and of course, more productive of goodwill and lasting relationships. And it has been repeated also in so many cases cited by the court that these are less expensive, speedy, and less hostile methods. And this is favored by the court. So if we have to review our civil code provisions on the aspect of compromise, or when can parties come up with reciprocal concessions. So Article 2028, for instance, of Civil Code provides for a compromise, that is a contract, whereby the parties, by making reciprocal concessions, avoid a litigation or put an end to one already commenced. And the parties may agree to a fair compromise of a dispute. And this has been recognized as well in the courts now with our Philippine Mediation Center and with our judicial dispute resolution mechanism as well, and even court annexed mediation. So take note as well that the Civil Code provides that no compromise can be made on the following: the civil status of persons, the validity of a marriage or legal separation, any ground for legal separation, future support, the jurisdiction of the courts, and future legitimity. So if the parties would enter into agreement on this matter, the same shall be contrary to law, and the same agreement is void. And we also take note that a compromise when entered into by the parties has the effect and authority of res judicata as between them. So take note that for the concessions that you make, you are bound by the same. And also we remember our Republic Act 7160 regarding, of course, the Katarungan Pambarangay system. So in our Katarungan Pambarangay system, we know that the Punong Barangay and the Lupo ng Tagapamayapa has certain roles in dispute settlements. And so anything that may have been agreed upon by the parties before the Lupo ng Tagapamayapa or the Punong Barangay may be executed, and the same is it's a valid settlement for as long as the matter is within the scope of Lupo ng Tagapamayapa. Even outside of the Philippines, in the international level, we know that ADR is widely used worldwide. Even in the United Nations Charter would provide that the parties to any dispute shall first of all seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, or other peaceful means of their choice. And that's so nobody is a loser or a winner, but both parties would benefit from the said arrangement or process. We have the court annex mediation in the Philippine Mediation Center. So we have the administrative matter by the Supreme Court on this, the cases before the courts in the first level and second level courts. The cases there may be subject to mediation, of course, under specified cases. And even if it is before the Court of Appeals, there is this so-called court of appeals mediation, where cases that would fall under the criteria in the administrative matter may be subjected to mediation in the Court of Appeals. We also have this concept of judicial dispute resolution. This is exercised by the courts after the mediation failed, for instance, and the parties are being recognized, or the parties are being required to go into this process, this time with a judge as the mediator or some sort of a middle person, and whenever the judge is finished with the judicial dispute resolution, or when the parties do not decide on the issue or do not agree upon a compromise, then the case will be raffled to another sala or another court, or the parties may so agree that the case will be heard by the same judge who handled the JDR process. So now we go to arbitration. So here in arbitration, arbitrator is appointed by the parties. There is a formal process regulated by arbitration procedures. So we follow, for instance, the model law rules of UNCITRAL, and we have adopted that in the ADR Act of 2004, and it is also actually recognized also by the special rules of court on ADR and the Supreme Court in its certain decisions, in several decisions, would recognize the same as a process. The parties input ideas and background, so it is an adversarial proceedings. Focus is on the rights and the past events, and the decisions are based on evidence and technical assessment. This is imposed by arbitrator among the parties. Okay, so there is this arbitrator who is acting like a judge, who will decide on the evidence or technical appreciation of the facts before it, and would render a resolution or a judgment on the particular dispute of the parties. What distinguishes them to litigation? So in litigation, so we have the courts, we have the judge who is appointed by the state, by the Supreme Court, Judicial and Bar Council's recommendation and appointment by the President of the Philippines. There is a formal process regulated by the new rules of evidence and, for instance, the new civil procedure. The role of a lawyer here is to act as an advocate and discredit opposition, whereas in mediation, for instance, the role of a lawyer is limited to giving advice. Sometimes the lawyer may even be requested by the mediator to go out of the mediation process. The litigation, of course, is an adversarial process where lawyers act in the party's behalf and focuses on the rights and the past events, and decision is imposed on the parties by the judge. So a judgment, once it becomes final and executory, a writ of execution may be issued by the court and the same may be implemented. So now we distinguish arbitration and litigation. So who resolves arbitration? Arbitration is being resolved by a private individual who may be selected by the parties, or who may be part of an arbitral institution, or if it is an institutional type of arbitration, maybe the listing will be provided for by the institution, or in cases where emergency arbitrators may be appointed, then the same may be governed by the rules of that particular arbitration institution. On the other hand, litigation is resolved by a public officer, usually the judge, or in quasi-judicial bodies, which has similar effect as litigation. So it must be a public officer that will be doing that particular decision or resolution. So what is the basis of jurisdiction in arbitration? Arbitration is governed by the agreement of the parties. So when we speak about arbitration, there is an arbitration clause or an arbitration agreement agreed upon by the parties and a component of their contract, whereas litigation is imposed by the law. All right. So enforcement, so whether it is voluntary or compulsory. So here in arbitration, since it was based on an agreement by the parties, the enforcement thereof is voluntary, but of course the winning party may ask the court to help in the implementation of the same judgment or resolution by the arbitrator, whereas the enforcement in litigation is compulsory. So by the order of the court, so the same must be implemented. So is appeal or challenge in arbitration allowed? So in arbitration, appeal or challenge is limited, generally because the voluntariness or the arbitration agreement would provide for the immediately executory judgment on the part of arbitration, and the special rules of court on ADR would provide for a limited ground on appeal and as to challenge the decision, such as, for instance, it provides that when the tribunal has not been properly organized, has not been properly set in accordance with the agreement of the parties, then it can be a ground to challenge the same decision. And as to the grounds, it's limited. Whereas in litigation, the rules of court would provide for remedies such as motion for reconsideration, we also have the appeal or other modes of appealing or challenging the decision of a trial judge, for instance. So what is similar between arbitration and litigation would be that in both, the decision is binding, and of course the outcome is binding decision. So we distinguish also arbitration versus mediation and conciliation. So the objective the objective of arbitration is to render an award that the parties may be given an award based on the proceedings. Whereas in mediation and conciliation, there is a settlement that may be arrived at by the parties. That is the objective. So the outcome would be an award or a settlement or no settlement for that matter. So as to the similarities, the basis of jurisdiction would be agreement of the parties. So remember that the parties may so agree as to what particular mode or mechanism that their dispute may be resolved. Okay, so who resolves in both? So it is private individuals as chosen by the parties. So remember the concept of party autonomy. So you don't forget that. As to enforcement, it is voluntary in both appeal and challenge, limited in both. So the arbitration, mediation, and conciliation, there is again a very limited ground to challenge or appeal on the decision or the agreement. Of course, we will be discussing that further if we have time in the latter portions of the presentation, or when you enroll at the VLC. So I hope you are enjoying this webinar, and please comment VLC. Now let's proceed to the ADR Act of 2004, which is the Alternative Dispute Resolution Act of 2004. So we remember these general principles of ADR. So I mentioned earlier about party autonomy. Here, this concept of party autonomy states that the parties, considering that they are the parties in the dispute, they can choose whatever they desire in order to settle the dispute before them, meaning to say that they can decide as to which particular venue, what particular subject matter may be decided upon by the tribunal, for instance, or if it is an arbitration, the tribunal, or even the limitations that may be decided upon by the parties. So it also involves the choice of the dispute settlement mechanism, whether it's mediation or arbitration, or whether there must be mediation or conciliation first before proceeding to arbitration. And of course, the policy to encourage and actively promote alternative dispute resolution. As I mentioned at the beginning of this lecture, the Supreme Court has been considering and in fact promoting the use of ADR in its effort to declog the court dockets. And we also congratulate the Office of the ADR or the OADR under the DOJ, and we congratulate, of course, Director Irene on this for helping truly the OADR to function as it is desired by the lawmakers in enacting the ADR Act of 2004. We also take note of the liabilities of the ADR providers. They are the same as liabilities of public officers under Section 30 of the Administrative Code of 1987, such as the clear showing of bad faith, for instance, malice or gross negligence, and all this may be meted out with certain liabilities as provided for under the law. And right now, the OADR is taking its effort in accrediting ADR providers or practitioners. So we congratulate Executive Director Irene and the staff of the OADR. Thank you, and I hope also to get my accreditation there. We are part of the team also that would be helping the OADR with a core group, of course. Now, so the law would define mediation as a voluntary process in which a mediator selected by the disputing parties facilitates communication and negotiation and assists the parties in reaching a voluntary agreement regarding a dispute. I think I have explained earlier what mediation is. So we have the court annex, and the court can refer the matter before the court annex mediation when the court has already acquired jurisdiction. And of course, as I said, there is an SC circular and memorandum on this already. And there are also mediation which are not court annexed, so covered by RA 9285. So there are institutions that provide for mediation processes or even trainings. So like the core group or other institutions. So it can be ad hoc or institutional as well. So we take note also of the features of mediation, which are important principles of alternative dispute resolution. So basic is confidentiality. So information obtained through mediation shall be privileged and confidential and inadmissible. So you take note of this, the principle of confidentiality in ADR proceedings. So even if it is even if it is arbitration, for instance, when the parties so agree that the same should not be published, the same should not, of course, be published based on the agreement of the parties, or the parties can as well agree if the decision will be published. So of course there can be exceptions to the confidentiality rule. That is, if the parties waive the required by law to be open, or there is a signed agreement between the parties, or there is a threat or plan to commit bodily injury or a crime or concealing a crime, to prove or disprove a claim of professional misconduct or malpractice filed against a mediator, and of course available in public or made in public. So the mediator is also required to disclose impartiality and conflict of interest. So a party may designate a lawyer or any person to provide assistance in mediation, only as to assistance. Okay. The law also provides for the enforcement of mediated settlements or compromise agreements. So the agreement between the parties may be deposited before the regional trial court, where one of the parties reside. By a petition to enforce the agreement may be filed with that particular court. And of course, hearing will only be a summary in nature. And parties may agree in the settlement agreement that the mediator shall become a sole arbitrator and shall treat the settlement agreement as an arbitral award that shall be enforced under RA 876. That was before, and of course, RA 9285. So there are other forms of ADR. So it may be asked before you in the bar examinations, what are the other forms of ADR? So there is an evaluation of a third person where the third person will evaluate the nature of the dispute, even as to the evidence. I think even the new rules on civil procedure would provide for the court to have an early neutral evaluation, of course, but this is not part of ADR process, but part of the court processes under the new rules. But the parties can as well decide on having another person evaluate for their kind of dispute. But of course, it's non-binding. there is also this mini trial, and of course the med-arb as a combination of mediation and arbitration. Here, there is the first step would be mediation and arbitration. Now, before we proceed to arbitration, I hope you are maximizing this learning session. You may tag a friend to this FB Live or host a watch party, of course. So now we'll proceed to arbitration. What are the sources of arbitration law in the Philippines? So we have the Republic Act 876, which is referred to as the domestic arbitration, RA 9285, or the ADR Act of 2004, and the implementing rules and regulations. We mentioned earlier about the UCITRAL model law rules. Of course, there is an amendment to the 1985 rules. The New York Convention, or the enforcement of foreign arbitral awards. Executive Order 1008, of course. The special ADR rules of court. The other laws and issuances referring to arbitration, such as in the Intellectual Property Code, the Revised Corporation Code, and of course the Financial Rehabilitation and Insolvency Act. So that is the legal framework for arbitration law in the Philippines. So we distinguish international arbitration with domestic arbitration. The law, the ADR Act of 2004, would be referring to the UCITRAL model law rules in its definition of international arbitration or international commercial arbitration. So an arbitration is deemed to be international when the place of business is in different states. So the parties may be involved in a dispute, for instance, where the business is involved in, for instance, in the Philippines, China, and Indonesia. So the same place of business, but place of arbitration is in another state. So the same is referred to as an international arbitration. Same place of business, but place of performance or subject matter of dispute in another state. And of course, when there is an express agreement that the arbitration is an international type of arbitration. And we remember that there is a distinction between a jurisdiction and venue of arbitration. So you take note of that. We will be trying to discuss that later on. And of course, domestic arbitration is arbitration that is not international. So I hope you are learning from this webinar. Share your takeaways so far by typing them in the comment section. So now there is also the special rules of court on the alternative dispute resolution. And this is being applied right now. So you have to be very careful in looking at the special rules of court on ADR, because like the periods here may not be the same as your new rules in civil procedure. So be careful with the specific periods. I would invite you to look into this. So maybe we'll try if we still have time. We are limited by only an hour in this webinar. So, but if you will enroll with VLC, you can learn more about this. So you remember the concepts of competence, and jurisdiction. As I mentioned earlier, the jurisdiction is not the same as a venue for purposes of arbitration. And jurisdiction, as you know, or as you can define under the rules of court, would be giving the tribunal or the court or this particular institution the power decide on a matter before it. Okay, so we remember this basic concept of competence. So sometimes it is spelled not with the English spelling of competence, but the German spelling. So the arbitral tribunal may rule on its own jurisdiction and on objections regarding the existence or validity of the arbitration agreement. So here, we remember that the tribunal is given that particular power to first determine its jurisdiction, whether it has jurisdiction over whether there is this agreement by the parties. So if you remember, there is, let's say, in this case of the Philippines versus China, there was first a ruling on the jurisdictional matters. So the tribunal determined its competence. So on the exercise of competence, the tribunal said that it has a jurisdiction over the subject matter of the case or the dispute. So it is also being determined in the competence issue as to whether there is an existence or validity of the arbitration agreement. That is why we always emphasize on the arbitration clause or the agreement, because sometimes the agreement would simply be the general terms and sometimes it lacks some details. So if you prepare your own arbitration clause or agreement, I think it would be advisable if we stipulate all the things that you wanted your dispute settled, just in case, so that there is no problem when you reach that point where there is a need to question the action of another party. We also remember this doctrine of separability, or the separability of arbitration agreement. It says that the arbitration clause, which forms part of a contract, shall be treated as an agreement independent of the other terms of the contract. So it can be a contract within a contract. So even if the tribunal would decide that the contract is null and void, it doesn't necessarily follow that the arbitration clause is void. Okay? So you understand the doctrine of separability in the area of arbitration. Okay, so the invalidity of the entire contract does not necessarily render invalid the arbitration clause. So the question there is, can the directors and officers be pleaded in the can the directors and officers be impeded in filing an arbitration case against a corporation? So in this particular case of Lanuza versus BF Corporation, the 2014 case, it states that directors and officers may be pleaded in arbitration proceedings to determine if the corporate veil should be pierced. Okay, they can be pleaded. So we remember that arbitration needs consent of the parties. As we said, it is a contract in itself, so there is a need for a consent of the parties. So arbitration is consensual in nature. So the elements of consent and agreement is necessary in arbitration clauses, of course. So it can be used for the sale of goods, commodities, or raw materials, shipping contracts, employment contracts, international construction contracts, financing agreements, and cruise ship tickets, and other matters. This is an example of an arbitration clause. Do you agree to this clause, or is there something wrong with this clause? although this is more of a general type of arbitration clause, the same is proper. So it is just up for the parties to include other points in their arbitration clause. So what are the points to consider in the arbitration clause? So you have the agreement to arbitrate. So you select the rules, determine the number of arbitrators. So we remember here that the rules, for instance, would be the guiding rules as to the parties, as to how the case will be resolved. So if they will agree that French rule will be applied, then the same should be followed. As to the determination of the number of arbitrators, the parties may so agree that it can be a sole arbitrator that is needed, or 3 persons or 5 persons may be considered as arbitrators. You choose the governing law, the procedural, and of course the substantive law of the matter. So you can also provide for optional procedural matters like time limitations, or whether mediation is necessary first before arbitration, or the language to be utilized, the discovery procedures, consolidation matters. So you may agree on that. The parties may also agree on the tribunal appointed experts. So if the parties may also appoint an expert based on their agreement. You take note also of the issuance of award, or whether injunctive reliefs can be allowed in this particular arbitration clause, or whenever the dispute would arise, can there be injunction or other reliefs that may be given at the very start. So that is considered as an exercise of the party's autonomy. So what is the usual procedure for arbitration? So of course, first is the filing of the request for arbitration. Then there is a formation of the arbitral tribunal, the submission of defenses and counterclaims, the pre-hearing meetings and preliminary hearing stage. There is a hearing stage, of course, and that would even require there the submission, for instance, to experts or technical matters. So there can be also a post-hearing submission, and of course the award that may be given by the tribunal in the dispute. So earlier we defined the domestic arbitration and international arbitration. So again, the binding effect of arbitration agreements are treated like any other contract governed by the Philippine Civil Code. Okay? Provided that the same is not contrary to law, morals, good customs, public order, or public policy, that agreement is binding on them. So, like for instance, even if the parties have agreed for this particular aspect, when the same is found to be contrary to public morals or public policy, the same can be declared as void. So I hope you are following our webinar. So, and I also wish that if you are reviewing for the bar examinations for next year, you are properly guided, you are properly relaxed, and I am praying for you. Okay? Please comment yes if you agree to that. Okay, so as I mentioned earlier, there are many cases decided by the Supreme Court on arbitration, and here in this particular case of Western Minolco versus Court of Appeals, the court said that there can be a situation that a limited arbitration clause has been agreed by the parties. Okay. So the parties can also agree on interim remedies, or if it is an institutional type of arbitration that you have agreed upon, you can go into those allowed remedies, or if not, you can secure an interim measure of protection for the court to grant such measure. That would be before the regional trial court in that has jurisdiction over the case. I mean, that has jurisdiction. So the arbitral tribunal or the Philippine court, remember, may grant a party an interim relief for the following purposes: to prevent irreparable loss or injury, attachment, for instance, to require security for the performance of an obligation, to require the production and preservation of any evidence, and to compel any other acts or omission. So there are developments on the aspects of this. There are even matters like the emergency appointment of arbitrators, and even of course other reliefs. As to the finality of arbitral award, within 1 month from the time an arbitral award is rendered, any party may apply with the Philippine court having jurisdiction over the same for an order confirming that award. So the participation of the court here is simply on confirming that particular award. So upon the granting of an order confirming, modifying, or correcting an award, judgment may be entered therewith in the court where the application is filed. And it would be the same as a confirmed arbitral award may be entered in the books of entries of judgment, and of course, the arbitral award becomes final and executory. Remember that earlier I mentioned about the voluntariness of arbitration. So after the judgment or the resolution of the arbitral tribunal, the judgment or the award is immediately executory. So the parties may voluntarily perform what is required under the award, or if not, the winning party may apply for the confirmation of the award before the courts. So you remember that in construction, in the construction industry arbitration, there is an arbitration as well, and the arbitral award there is executory and need not be confirmed by the Philippine court. And you also take note specifically on the arbitration before the CIAC, the construction industry arbitration. Remember that if there is a contract between the government and a private individual, a contractor, for instance, and upon entry to the same, upon the grant, for instance, of the bid or the award of the bid before that, on that particular contractor, for instance, if there is a conflict or a dispute that would arise in the construction, that is the matter between the government and this particular contractor. This matter should first go before the SIA and not before the courts of law, as also mentioned before the Procurement Act or Procurement Law of the Philippines. We also note that an agreement by the parties that the arbitral award or decision shall be final is valid under the Philippine law. In a case decided by the Supreme Court, it does not deter the courts from reviewing an arbitral award where appropriate. So we remember again that there is a limited power on the part of the courts in the areas where arbitration is involved. Okay? So there must be a ground for vacating, modifying, or rescinding an arbitral award. So we now go to international arbitration. Do we still have time? Okay, so we'll proceed to international arbitration. Please comment. The rules here in VLC would say that please comment VLC if you believe that you will pass the bar examination. So we'll try as much as possible to discuss this matter on international dispute resolution or the arbitration, international commercial arbitration, and some of the rules. Okay. Enforcement of arbitration agreements. The establishment of the arbitral tribunal is the same, so you can skip on this. So I mentioned earlier about the United Nations Commission on International Trade Law, or the UNCITRAL Model Law Rules. And as I said, we are following the model law rules in the ADR Act of the Philippines, and even in our special rules. And we also know that the different arbitration centers near the Philippines, such as the Singapore Arbitration Center, Hong Kong, or even the WIPO has been using the same. So an arbitration is international if the parties to an agreement have their place of business in different states. As I said earlier, one of the places is situated outside the state in which the parties have their place of business. The place of arbitration is determined by the arbitration agreement, etc. So you check on your rules. Okay, there is also this definition of what commercial is. Okay, so UNCITRAL Model Law rules. So arbitration must be in writing. So unless the parties otherwise agree, the arbitrators is 3. So they can determine the issues based on a majority of them. So each of the party would appoint 1 arbitrator, and the 2 arbitrators, once constituted, would appoint the 3rd member. So they are called the tribunal. The tribunal has the power to make preliminary, interlocutory, or interim orders as between the parties. Okay, so you read on the UNCITRAL Model Law rules. I also mentioned earlier about the New York Convention, or the enforcement of foreign arbitral award. So it is a situation where, for instance, a Filipino company entered into an arbitration agreement with a company in New York, and their arbitration agreement states that the venue of their arbitration would be for instance, in London Arbitration Center. And so the London Arbitration Center rendered a resolution or an award based on the arbitration agreement. So now the Filipino company, since it is the winning party before the London arbitration proceedings, then it can be enforced here in the Philippines. So the Filipino company may file a matter before the court of law in the Philippines for purposes of recognition of the foreign judgment of arbitration or foreign arbitral award in in the Philippines. Okay? Remember that the New York Convention applies only to international commercial arbitral agreements, and the same may be applied here in the Philippines as well. Okay, so the New York Convention applies if three basic requirements are met. The award arises out of a legal relationship. The relationship is commercial in nature, and the award arises of a relationship not entirely domestic in scope. And of course, the convention allows for recognition and enforcement of an award that complies with the laws of the country where the arbitration occurred. So the decision or the award should include therein the jurisdictional basis as to whether there exists an arbitration clause between the parties. Okay. The tribunal's decision, a direction to the parties, or of course that particular action that should be done by the parties, which should not be ambiguous or vague. It must be clear as a direction, and it's not as well conditional. Okay. Otherwise, there is a problem with the enforcement of the judgment or the award. So the decision also would include the analysis of the legal and factual basis for the award. Okay, you remember that. So under our ADR law, Section 42 would provide for the application of the New York Convention. So the recognition and enforcement of such arbitral awards shall be filed with the RTC in accordance with, of course, our special rules of court. Okay? So we take note as well that the foreign arbitral award is not considered a foreign judgment. So when confirmed by a court of a foreign country, the same shall be recognized and enforced as a foreign arbitral award and not a judgment of a foreign court. When confirmed by the RTC, shall be enforced as a foreign arbitral award and not as a judgment of a foreign court. Remember that if it is a foreign judgment, the rules on civil procedure will apply, whereas in foreign arbitral award, the special rules of court on ADR would apply. Okay? And a foreign arbitral award is considered as a final and executory decision of courts of law of the Philippines. So again, just to remind you, what are the roles of the court in arbitration? So enforcement of arbitration agreements, to render interim reliefs, for instance, in cases when the tribunal has not been established yet, or when the arbitration clause would allow for the interim reliefs. Okay, of course, the enforcement of arbitral awards, vacating, modifying, correcting arbitral awards, although I said earlier that it will be on a limited basis or limited grounds, and of course appealing arbitral awards. But remember that, again, the general rule is that arbitral awards are final and executory, except that there are matters that would require the courts that would allow the parties to appeal or the parties to question the judgment based on, of course, again, specific grounds. Okay? So just a review. So the principle of competence. So the tribunal have to initially rule on its own jurisdiction. So to determine whether it has a competence to respond or to rule on the request for arbitration. This principle of separability, of course, it means the clause shall be treated as an agreement independent of the other terms of the contract of which it forms part. And of course, the decision that the contract is null and void shall not entail ipso jure the invalidity of the arbitration clause. The principle of separability. I think it will be coming out in the bar. Principle of separability and competence. Okay. So who may request recognition and enforcement or setting aside? So any party to an international commercial arbitration in the Philippines may petition the proper court to recognize and enforce or set aside an arbitral award. So it may be filed anytime from the receipt of the award. Okay. It must be filed with the regional trial court where arbitration proceedings were conducted, where any of the assets to be attached or levied upon is located, where the act to be enjoined will be or is being performed, where any of the parties to arbitration resides or has its place of business in the national capital region. Okay, so if you agree to this, you can comment in the comment page VLC. Okay. So what are the grounds to set aside or resist enforcement? So a party to the arbitration agreement was under some incapacity, or the said agreement is not valid under the law to which the parties have subjected it, or failing any indication thereof under the Philippine law, or the party making the application to set aside or resist enforcement was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings, or was otherwise unable to present his case. Okay. Here, Rule 12.12 would state that there is a presumption in favor of confirmation. So it is presumed that the arbitral award was made and released in the due course and is subject to enforcement by the court unless the adverse parties is able to establish a ground for setting aside or not enforcing an arbitral award. Rule 13, recognition and enforcement of a foreign arbitral award. So who may request for recognition? So any party to a foreign arbitration may petition the court to recognize and enforce a foreign arbitral award. So at any time after receipt of the foreign arbitral award. Again, before the RTC to recognize and enforce such award. Again, remember that a foreign arbitral award is not the same as the foreign judgment of a foreign court. Okay, so it should be treated as a foreign arbitral award. Okay, so we are now in the final part of my presentation. So I was told that I only have 15 minutes left. Please comment yes if you are learning a lot from this session. Okay, so where is the venue for the filing of the enforcement of a foreign award, recognition and enforcement of a foreign arbitral award? So the venue is the regional trial court where the assets to be attached or levied upon is located, where the act to be enjoined is being performed, or in the principal place of business in the Philippines of any of the parties. If any of the parties is an individual, where any of those individuals reside, or in the NCR. Of course, again, it's the regional trial court. So again, we remember the New York Convention on the Recognition of Foreign Arbitral Awards, or the New York Convention. Okay. I hope you are trying to absorb this many cases. I mean this many topics about the ADR, and there are many cases involving the Philippines in the let's say ICSID, or the International Center for Settlement of Investment Disputes. And I think one of the cases here would be on the this SGS, or the Societe Generale USA versus Republic of the Philippines. There is also this, of course, this famous case of the Philippines, Fraport AG Frankfurt Airport Services Worldwide versus Republic of the Philippines. That would be involving the NAIA Terminal 4. There are two cases here involving the Philippines. The second decision, there was no contract between Philippine government and Fraport to enter into a contract for the building or operation of NAIA 3. So Fraport is only a creditor of the Philippine International Air Terminals Corporation. So it is Piatco that has government contract to build and operate the new terminal in Pasay City. And Fraport has 40% equity in Piatco and reportedly advanced money that its Philippine partners needed to satisfy the 60% Filipino capitalization requirement. So for violation of the Philippine laws as well. Okay. So in this case of Korea Technologies versus Lerma and Pacific General Steel Manufacturing Corporation, a 2008 case, the court said that in our jurisdiction, the policy is to favor ADR in resolving disputes in civil and commercial disputes. Okay. So the basic question there here in this particular case is whether the agreement of the parties to bring the dispute in Seoul, Korea, as its venue for its arbitral proceedings is valid and binding in the Philippines. So here the court said that it is a valid agreement between the parties. Okay. So in this particular case, the court outlined the many cases where the arbitration clause was mutually and voluntarily agreed upon by the parties, and the same has not been shown to be contrary to law or morals, good customs, public order, or public policy. And it's in one case, the Gonzalez versus Climax, the Supreme Court said that submission to arbitration is a contract, and that a clause in a contract providing that all matters in dispute between the parties shall be referred to arbitration is a contract. Okay? So, again, we go back to the concept of autonomy of the parties, and so the contract may be valid as between the parties. So, here in this case of Korea, the arbitration clause is not contrary to public policy. So if the arbitration clause stipulates that the arbitration must be done in Seoul, Korea, in accordance with the commercial arbitration rules of KCAB, and that the arbitral award is final and binding, it is not contrary to public policy, and therefore it is allowed and under the Katina of cases decided by the court in the Philippines. Okay, I have so many cases actually, but maybe this would be the last. So here in this case of Tuna Processing Inc. versus Philippine King Ford Inc., 2012 case, the question there is, can a foreign corporation not licensed to do business in the Philippines, but which collects royalties from entities in the Philippines, sue here to enforce a foreign arbitral award? The court said yes. Because here the court dealt with the distinction between the corporation clause, corporation code, which is a general law on the formation, organization, and regularization of private corporations, versus the ADR Act of 2004. And it said that the ADR Act of 2004 is a special law that relates to the dispute settlement mechanisms, and therefore it is that the agreement of the parties is valid, and even if it does not have it does not conduct business in the Philippines, then it has the right to bring an arbitration case against the other party. So there are many cases here, but we are limited by time. So we only have an hour actually given to us. But I know that you are learning a lot from this session, and so I would like to thank the VLC, of course. I would like to thank for watching and for staying until the end of my presentation. Please visit the VLC website at www.Villasis Law Center to know more about the virtual law companion. Prepare for the bar examinations at any time, anywhere, and from any mobile device. Together, we can. So you can keep in touch with VLC, and also you can follow me in my Facebook account or my Facebook page, Dean Rodel Taton, and please watch out for our new show, the I Know Right, that will be shown in YouTube. So like, subscribe to Tayo TV, where I will be part of this show on I Know Right. I would like to say thank you. Okay, so thank you very much.
you.